This is just a couple of notes on subcomponents of the genericism question about timing and surveys. First, timing. What's the relevant time period for assessing genericity, now or when the mark was registered, if it is? There are at most three cases where courts allowed a company to reclaim a trademark after it had been held generic. Singer for sewing machines, which was found generic in the 19th century, Goodyear for tires, and arguably Opry for Grand Old Opry. In no case, however, has a term that's born generic been allowed to be appropriated by a single source. The possibility of genericide means that we look at the present time. And that makes sense because with genericity, the competitive concerns tend to outweigh the benefits of letting businesses have certainty about their rights. However, we will also look at the time of registration, which can create an independent barrier that will be hard or impossible to overcome because of the policy against allowing anyone to withdraw a truly generic term from the public domain. One court notably held that Windows might well have been generic at the time of its adoption for computer graphic user interfaces, which would make the mark void from the beginning. Microsoft settled that case rather than litigate it. Another court dealt with an interesting related situation. Fire cider is generic for a type of herbal remedy, but only known within the herbalist community. The plaintiff registered fire cider and started promoting its herbal product among the larger population. The court found that when the plaintiff began using the mark, the product only had limited appeal and it was generic to the subset of people who knew what it was. So plaintiff couldn't appropriate it and popularize it as a mark. And of course, there's a continuity here with the doctrine of foreign equivalence, which doesn't allow people in the US to claim foreign terms that are generic in another language. Many genericism cases don't turn on timing at all. More of them are much likely to much more likely to turn on surveys. So we'll say a lot more on surveys in class, but I'm going to make some introductory remarks now. Surveys are generally considered the gold standard for evidence of genericity or non-genericity, but what do you ask? So here are some classic cases. The Teflon case, the first appearance of what became known as a DuPont or Teflon survey. The defendant's survey asked for the name of pots and pans that have their inside surfaces coated to keep grease or food from sticking to them. The overwhelming majority answered Teflon in response to this question. The plaintiff's first survey flipped the default. Instead of asking for the name, it asked, do you know a brand name or trademark for one of those coatings? And what is it? Of the 60% who knew a trademark, 80% answered Teflon. Then they were asked, can you think of any other word to describe those coatings? Of those who answered Teflon, 32% supplied an additional term like nonstick, and the rest couldn't give another term. So what about those 68% who couldn't think of another term? If Teflon is not generic, how is a competitor supposed to market to those people? And the question you might have is, well, will nonstick be immediately recognizable as an alternative? So there is a difference between top of mind production, being able to think of something on your own when you're cued, versus recognition when you actually see the thing. And that probably gave the court some comfort with allowing Teflon to remain a trademark. Nonetheless, it's pretty clear that survey didn't go too well for DuPont. So DuPont's second survey used the example Chevrolet and automobile to explain the difference between brand names and common names. And it asked whether each of 8 names was a brand name or a common name. And you see some very interesting results here. So 6% of people think refrigerator is a brand name. 9% say margarine is. 13% say aspirin is. This is in 1975, a generation after aspirin was found to be generic. And we need to think about whether these clearly wrong answers tell us anything about this survey or surveys generally. So along with this sort of training, we have 2 potential tests. First, what's the principal significance of the term to the consuming public? Second, is there a lack of an alternative generic descriptor? And in the Teflon case, the court picks number 1, what's the principal significance of the term to the consuming public, over number 2. And indeed, if the result were otherwise than it is in this case, it would be extremely hard for DuPont ever to preserve a trademark on a product with a complicated chemical name. Although, of course, it could invent two names, as pharmaceutical producers routinely do. So Aleve and naproxen are both fanciful, but one is a trademark and the other is generic. So there's a relevant recent Supreme Court case, Booking.com. Booking.com fits the pattern of change in trademark law since the Lanham Act was adopted. Courts have shifted from accepting prophylactic rules to promote competition to prioritizing the idea that protection against likely confusion is king, and any other interest should be considered only in individualized circumstances. So limits on the registration or protectability of trade dress, limits on territoriality, and numerous other rules have all been relaxed. The modern reasoning is, let putative owners claim a mark if it functions as a mark, and let any anti-competitive or speech-suppressing consequences be dealt with as defenses for individual defendants. The biggest reason not to register Booking.com is the power it gives the registrant to credibly threaten competitors like HotelBooking.com, even though its rights pretty clearly shouldn't extend that far. The majority thinks that case-by-case adjudication will protect potential competitors. The dissent thinks forcing them to litigate is too dangerous. And one result of Booking is very clearly the opportunity for arbitrage. So if you attempt to register your borderline term, the PTO actually has the burden to show genericness under its interpretation of the statute. So if the evidence is in equipoise, you get your registration. And then registration will provide you a presumption of validity you can deploy against subsequent genericness challenges. But there wouldn't be that presumption if you hadn't registered. Now, one might think the risk of arbitrage is minimal because the burden of proof so rarely matters, but the Booking.com case might itself be evidence to the contrary. And remember that competitors might not be showing up to produce alternate evidence in a registration proceeding. So we'll talk in more detail about the Booking.com survey in class. What I want to highlight here is that most other genericism survey cases, except for pretzel crisps, predate Booking.com. Nonetheless, if you take the PTO's concession in Booking.com that the survey actually showed trademark function as a key fact, then all the survey cases are still valid because they're actually about what the surveys do show. So I'm going to show you an example of a survey from Subway's footlong application. And if you look at footlong, how it does versus other things that are acknowledged to be brand names, and so you can see this is a Teflon survey. They've trained people and they've asked them to put a bunch of different terms in the category brand name or common name. And footlong doesn't do super well compared to things like Gatorade or Doritos. On the other hand, it actually looks a lot more like a brand name than the results for, bottled water or side dishes. So it's closer to the brand name results, not by a ton. This isn't too different from the pretzel crisp surveys, which you've seen discussed in the Ginsburg materials. The TTAB rejected this survey as it did in pretzel crisps. So the formal doctrine, which I just told you, surveys are the gold standard. Practice may be a little different. In both pretzel crisps and footlong, the TTAB did not like the examples that the expert used to train respondents before they answered the questions. And of course, training is necessary in a Teflon survey to make sure that the respondents understand this question that they're answering, which they may never have contemplated before in their lives. So in pretzel crisps, the respondents were trained that wheat thins, which the PTO thought was highly descriptive, was a trademark. And the PTO didn't like that. Likewise, in Subway, the respondents were trained that the highly descriptive terms quarter pounder and original recipe were trademarks. And the PTO says, it's true, those terms have acquired distinctiveness, but using them as canonical examples of trademarks might have led respondents to believe that extensive advertising for terms like footlong was enough to make that a trademark too. There might be de facto secondary meaning, and consumers could have responded to that. Also, the TTAB said that the survey shouldn't have allowed a both answer because that's impossible. I think that's wrong in theory, but it's worth noting that the both answer only garnered significant numbers of responses for footlong, not the other examples, suggesting that consumers really were confronting a kind of deep uncertainty there. Now, there is an opposer in the footlong case, and in their survey, only 3% of respondents said that Coca-Cola was a type in this survey, compared to 21% who said that Diet Coke was a common or generic name in Subway's survey. So the TTAB pointed to that result as evidence that the opposer survey was doing a lot better at training respondents, because of course we know Diet Coke must be a trademark. The divergence between surveys is not uncommon. It's one reason courts often don't trust surveys very much, despite calling them a gold standard before they see the actual one that the party has put in. Likewise, we see in Pretzel Crisps, another Teflon survey, the TTAB didn't like the applicant survey. It also didn't like the opposer survey because it had both a don't know option and a not sure option, which could have been confusing. On the other hand, if you look at these other results for the terms not an issue, it doesn't seem to have been that confusing for most of the other test items, again, suggesting that there's something different about Pretzel Crisps. And here, by the way, is the applicant survey. It's actually a little encouraging that there's only a 14-point swing in favor of brand name with the applicant. The surveys here weren't completely biased. Probably the answer is there's a mix of generic and brand meaning. So we'll have much more to say about what surveys can and can't do in class, and I will see you then.